Hi, good morning, everyone, and thank you for joining us for our webinar today, brought to you by Innovate Hawaii, part of the Hawaii Technology Development Corporation. My name is Ellen, and I'm the Economic Development Specialist here at the Hawaii Technology Development Corporation. Before we dive into the webinar content, I have a couple of reminders and announcements for everyone. Firstly, this session will be recorded and uploaded to YouTube. We will share the link in the post-event email, and you can also find it on our website, htdc.org/ecommerce. We will share the link in the chat box later. You're also welcome to send in your questions during the session through the chat function, through the Q&A function, and we will address them when appropriate or during the Q&A portion of this webinar. For those who have joined us today and for making it to this webinar, we'll also be sending you the privacy template from Hew and Bordenave by email. I would really appreciate it if you could change your display name in Zoom to reflect your first name and the first initial of your last name. If you don't know what that means, look at my name, Ellen, and then N dot. So this would allow us to identify you using our registration list and then be able to send you the privacy templates and other templates that Ryan has prepared for the attendees today. I would also like to make an announcement about our upcoming webinar on electronic data interchange that's happening on November 10th, next Wednesday from 12 p.m. to 1 p.m. If you are a business owner interested in leveraging EDI technology to enable automated exchange of business documents like purchase orders, invoices, and shipping notifications between trading partners, I think this will be a great webinar for you to join. We will leave the link to the webinar in the chat box as well. Another exciting announcement, we have an opportunity for companies who are already in e-commerce, but interested in expanding into Japan. So through our partnership with the High Step program, we are extending grants to companies to build out their e-commerce and digital marketing capabilities to take on the Japanese market. We will leave the link in the chat box for you to submit your application for the grant. So today, I'm really excited to have Ryan Hew from Hew and Bordenave, who will be sharing with us the best practices around data and privacy management in the context of e-commerce and digital marketing. Ryan's expertise lies in business law, in particular transactions and compliance. He has also assisted clients in forming their LLCs and corporations, buying, selling their businesses, obtaining licenses and permits, as well as drafting contracts and filings for business matters. So I see that Ryan has joined us. Thank you for coming today, Ryan.
Thank you for having me, Ellen, and thanks for setting everything up. Awesome. Anything else to add, or?
You can do a deeper introduction if you like to, but if not, why don't you turn on or enable your share screen to see if your presentation slides work, and then I'll disappear and let you take over.
Don't go away too far. How's that?
Okay, looks great. All right,
Perfect.
So I'm going to let you take over. Thanks, Ryan.
No, thank you for that wonderful introduction. And again, thank you for HTDC and Innovate for having me. Thank you for everybody who has showed up this morning to listen to some exciting stuff. I apologize. I'm just going to let you know up front that this is a very word-heavy presentation. My hope is that you can take my PowerPoint presentation with you and kind of convey it and then reference it back. I have violated my own personal rule of walls of text on each slide because the subject matter is very meaty and very dense in terms of just word usage. But quick background, just to add what Ellen said, is I tend to help small to medium-sized businesses, and frequently there are questions about website terms and conditions and privacy policy, which is why I'm presenting today's presentation from that angle. That being said, I know we have, I believe out of the 30-something odd of you, a mix of industries. My primary kind of target, or who I usually help in that type of situation in terms of their website terms and conditions, are small professional businesses or consultants or retail. If you're in, let's say, manufacturing or engineering or other kind of industries, just recognize that that's kind of the background that I'm coming from. So there will be a question and answers. We have a lot to get through, so I'm going to just jump into it, but please feel free to ask your questions and hopefully we can address some of them at the end. The other thing, oh, by the way, the other thing about this presentation, in reference to the slides and my whole thing about the wall of text, they're done in a way in more of a, what I call an outline or written kind of white paper style. So again, it's for you to cross-reference should you zone out, think about what's for lunch today, or you have to, if you're working from home and listening to this, you have to take care of the kids or the dogs. So feel free to jump in and out, but understand that the presentation actually has a lot of information in it. So jumping right into it, of course, being a lawyer, I'm going to put a disclaimer. The whole webinar, including the sample documentations that you will get, and actually beyond just the sample kind of template privacy policy, there's a number of other documents that I've provided that we're going to touch upon in this webinar towards the end. So all of it tends to educate you. In fact, today's presentation is very topical on privacy regulation. And so what I would like to impress upon you is, and what you're going to see a lot with the regulation is, it really is going to be a case-by-case analysis. And then you're probably definitely going to need your tech people, especially if they're responsible for your cybersecurity, and if you're not a cybersecurity, if you're a business owner per se, of jumping in on this. What I'm trying to get at is that today's topic will probably require a lot of assistance from a number of specialists, not just an attorney or a compliance officer. So anyway, that's my kind of disclaimer. So what are we talking about today? Agenda-wise, we're going to be discussing data privacy laws and regulation, in particular as the flyer for today's seminar. Basically, we're going to be focusing mainly on GDPR and CCPA. We'll get into that more in section 2, but first part is I'm going to kind of give you an overlay of where we stand in data privacy law. This kind of assumes that most of you are in Hawaii businesses, and you're kind of looking outward to expanding or overseas markets, and what that kind of really means and what the state of regulation kind of looks like, for what you kind of have to understand about the system. Then jumping down, we're going to examine the regulation. As I said, we'll talk about mainly GDPR and CCPA. Just to be blunt in terms of it, it again is a very topical. You could have a whole day talking about GDPR compliance. In fact, if you're trying to implement compliance situations, it's a very lengthy, time-consuming process that will probably take you months to kind of implement if you are not GDPR compliant. That being said, just a short of that is, the question is whether or not GDPR applies to you. So that would be the second part, is examining the regulation. We will talk about some Hawaii laws, but you're going to discover there's not much in the way of data privacy laws for Hawaii. Jumping down to the third component, we're going to be thinking about your privacy policy and what it means for you when you're trying to roll out a privacy policy that kind of comports to GDPR and CCPA compliance. Finally, that last fourth section is, as I've kind of already hinted on, it's not just an internal discussion with yourself, with your own business, your employees or your compliance officer. You're going to have to enter into a number of agreements or implement certain kind of protocols and procedures when working with third parties. And so we're going to jump into that a little bit. And then hopefully there's enough time at the end in terms of questions and answers. Okay, oops. Sorry, gotta move the window. Okay, so data privacy regulation. If any of you are following the news, I'm sure, well, over the past couple of months, you've probably seen the Facebook whistleblower that dumped hundreds of confidential documents out, and we've been reading about how Facebook has been violating, or basically not truthful in terms of its representations. In addition, there's a number of psychological studies on what social media does to us, or how people interact with it. And then, of course, almost daily, if you subscribe to a bunch of news feeds or follow it in terms of security and privacy news, almost daily there is sets of data hacks into large corporations about stealing credit card numbers, travel reservations, things like that in terms of personal identifiable information. And that's kind of what we're getting at. And what we're seeing now, especially with here in the United States, is that a few states, California, Virginia, and Colorado, are kind of leading the way in terms of setting up regulation on companies on how they respect the data that they collect from their consumers and customers. Obviously, for those of you that remember it, when GDPR, which is a European Union regulation, that you had tons of emails from Amazon, Banana Republic, Etsy saying we're GDPR. I mean, so there is a shift in terms of government actors, whether they be countries, states in the United States, about dealing with that so many companies have your personal identifiable information in their databases. And nowadays, most of the goals of these regulations is to protect that individual or that person's privacy. And it accomplishes this mainly by setting forth the requirements that you guys, your companies, must meet when you're collecting and processing certain kinds of data. So you'll see it's not all kinds of information or data, but it's only certain types. Further, and you'll especially see this in European Union's GDPR, is that there's a lot of investigatory and enforcement powers given to government agencies. And this is the part where attorneys kind of get excited, is, well, especially if you're into litigation, is in certain instances, certain regulations do provide the customers a private cause of action. That is the ability to sue the company for their data practices or lack thereof. So that's really how the regulation, the newer regulation, is broken down to. So again, this is just a reiterance of the prior, but jumping down to the bottom line is that, if data privacy regulation applies to you and your company, and you have not implemented or are, in a sense, abusing the data that you collect from your customers and consumers, you can basically face hefty fines and penalties. We're going to go into some of it, especially on GDPR, with kind of eye-popping numbers. And yes, those are large global corporations. But the thing is that if you want to continue doing business online and provide the services or products that you do, obviously nowadays customers and consumers expect, on the one hand, they expect ease of use of using your website or your app, but to do that, you have to collect their data. And if you don't have a firm understanding about how privacy laws work, nor do you have any policies internally, that is to train your employees about how to handle this data and information, and you don't have policies, or actually you don't follow your own policies, and you'll see more about that in other examples, that is your external policies to to the public and to customers, you're going to run afoul a lot of times with these regulations. And for most businesses that intend to grow out of that small to medium and then start conducting business in overseas markets or into California, yeah, this is something that you're going to have to grapple with. So jumping down to just an overview of the regulations. So what is kind of the state of data privacy regulation? Unfortunately, this is the headache for compliance, and this is really why it's going to be a case-by-case analysis for many of you. Is there is no like one set of laws that says this is the only thing you need to do and you are now 100% compliant. Unfortunately, because we're broken up into various countries and states, and the internet and kind of way tech is done, is that there isn't a set of uniform laws. In fact, after we talk about CCPA, you may want to, if you're considering doing business in Virginia and Colorado, is comparing and contrasting the way they talk about their privacy law. But anyway, we're going to talk about a few federal laws. I'm mainly going to focus on the Federal Trade Commission Act and the Federal Trade Commission as an agency. And then again, there are country actors, or at least an economic bloc, which is the European Union. So again, we'll be focusing on GDPR. And then there are states. And today's focus will again be CCPA and Hawaii, some of Hawaii's laws. Now, obviously, if you're thinking of doing business in Japan, Australia, Mexico, or other countries, some of them have their own data privacy laws that match, or sometimes are very loose and relaxed. And so a lot of times, for instance, if you go to Facebook or if you go to Amazon, they actually have different pages and different policies that apply to different countries based on basically how they handle regulation and their compliance. So oftentimes when you're thinking about the law, is you have to kind of do a whole kind of analysis. Is who are you collecting data from? Because you'll find that a lot of times these laws only apply to consumers and not businesses, nonprofits, or certain government agencies, or in certain types of industries. And then jumping down from that, what are you collecting in terms of pieces of information? 9 times out of 10, the information that's protected by data privacy is what we call kind of personally identifiable information. That is, I can take this piece of information and identify the consumer. If I had that, I would know their credit card number, their name, their bank account number. I would know health information, their gender, things like that. And so not all information is covered by data privacy, but you need to kind of figure out what you are asking. And when people log onto your website and they fill out your form or your questionnaire, what are they giving you? Then a lot of times data privacy regulation is concerned with businesses, private endeavors. What are you doing with this data? 9 times out of 10, obviously it's for most of you, like, well, duh, we're collecting this so we can fine tune our products and services and our digital marketing and advertising. We're going to kind of micro target and show you exactly the ad for the exact kind of service and product you need. It goes without saying that is exactly what business and consumer advocacy groups are concerned with. So there is always a purpose question in terms of what you are doing with the data. And then finally, you're going to see a lot of times the way, because of the mishmash or patchwork of laws, again, that different states have different laws and the EU has its own kind of set of regulation through the GDPR, is where are you advertising? Where are you marketing? Where are you selling your products and services? Just because we're in Hawaii and a German citizen happens to be on your website looking for how to make Hawaiian pizza because that's in their mind, that doesn't necessarily mean if you're going to collect information from them by happenstance or one-off instance that GDPR applies for you. So again, that's the kind of analysis that you have to do for each jurisdiction that you're going to be entering. Again, when I say jurisdiction, I'm talking about each country and each state, and sometimes in certain instances on a county or a very local level, depending on what country you're working with, because some of them obviously break apart their cities by a municipal level. Okay. So before I jump into examining the regulation, I do have a word about the applicability part. So I know I just talked about, you may discover in terms of your analysis that GDPR or CCPA doesn't apply to you. Maybe you are solely doing business-to-business interactions, or you're not even collecting consumer data. What you need to understand, especially if you're going to be entering in the consumer atmosphere, or when you begin to look at a variety of websites and apps, is people begin to expect uniformity. What I mean by that is, if GDPR and CCPA apply to Amazon, Facebook, British Airways, Google, the thing is that they all implement and become code compliant. But when consumers or customers interact with their websites and then turn to yours as a small business or a medium-sized business, the consumer mindset, because all consumers are law experts on privacy, they begin to expect that level of privacy protection, even though they don't understand that the law or regulation may not apply to you. I have a very kind of, by way of tangent example, or at least by a simile or meta, is that a lot of criminal law in terms of prosecutors having to present evidence, they noticed that in terms of social effect on jurors is that there was what they called the CSI effect, is that, oh, why don't you have that kind of evidence to produce for us to, that they do on the show, the CBS show CSI. And, the funny thing that we lawyers take away is it's very funny in terms of how social pop culture, or how mass media or large cultural institutions, corporate cultural institutions, again, like Google, right? We use Google as a verb in our everyday parlance, how that begins to impact the minds of everyday people in terms of their expectations. So to distill all this part of the slide is, even if the regulations don't directly apply to you, it is kind of wise, if you're expanding, growing your business, that you consider that what this is having on the general kind of population and the consumers. And especially if you're in retail or dealing with consumer data as a one-off, maybe you're a vendor or you're a tech company selling data processing servers to retail. Again, you may have to understand that the regulations will eventually apply to you, or there might be a situation where there's an expectation that we have this data privacy. Okay, jumping into the first kind of meaty kind of topic in examining the regulation. We're going to go through federal, then GDPR, then the CCPA, Hawaii, and then I have just one short little miscellaneous slide just to kind of raise the issue for other states and countries. So jumping into federal law. So again, there is no uniform, with congressional gridlock and kind of deep political polarization, there isn't a kind of a uniform set of federal law that says all you private companies have to do this to protect consumer privacy or data. Instead, we kind of back into it in terms of the laws that we already have of that there is some type of privacy right to people's information. And in fact, by now, many of you may have heard these acronyms. There is the FTCA, there is HIPAA, it is HIPAA, not HIPPA. I will talk about that in a minute. FCRA, FERPA. You've probably heard about these through your various interactions. You know, maybe you've interacted with FERPA if you have kids. Maybe when you've gone to your doctor or medical provider, you've seen HIPAA, right? So many times for these laws that are already on the books at the federal level, they do not directly deal with privacy. In fact, a lot of times they have broader goals and they're more industry specific. Again, HIPAA is mainly for health information. FERPA is on education. FCRA is more for credit reporting and credit bureaus. So again, the protection for data and people's information is sometimes only inferred in the federal regulation, or it's an afterthought. So the main one we're going to be concerned about today, and that I'm going to focus on this big kind of examining federal regulations, is the Federal Trade Commission, which is an agency. The law, the Federal Trade Commission Act, is what gives the FTC the power to investigate and prevent unfair methods of competition and deceptive acts that basically impact commerce. The FTC basically has two goals of protection of the US economy, is to promote kind of, or at least kind of maintain fair competition and going after unfair competition kind of acts. So that's why the FTC sometimes targets monopolistic behavior, is to break up monopolies. And on the other end is to protect consumers. The FTC can issue fines and penalties against apps and websites that violate their own privacy policy, and that's one way that they kind of protect consumers. They also investigate marketing language that relates to privacy. Therefore, if you put out website terms and conditions and privacy policies that you're not following internally, or you're breaking your own terms and conditions and privacy policies, they will investigate that. So what are examples of this? So it's not without irony that the first one I chose as an example was the FTC filed a complaint against Zoom for deceiving its users by basically they made this statements and representations that the video chats were end-to-end encrypted, when in actuality they weren't. Obviously, on an economic and pragmatic scale, because of the pandemic, Zoom found itself growing exponentially. They probably overpromised, undelivered, and wrote policies, representations, and terms conditions that were not true. So earlier this year, Zoom settled with the FTC, and they're subject to assessments. Those are yearly reports and audits on their practices to make sure they're implementing and updating their IT and marketing practices. So note that the settlement with the FTC did not include compensation for users. That is, the people who felt, again, on the consumer protection level, that the settlement with the FTC did not include monetary damage or penalties. The FTC sometimes has powers, exactly as I said, to fine companies for violating their rules or their terms and conditions and policies. What that meant is class action attorneys representing people complaining basically filed a suit against Zoom using the information collected by the FTC. So a lot of times for us attorneys, we let the government agency and regulatory action do all the discovery and pull out information. And then if they don't go for monetary damages or a way to recompensate the injured victims or plaintiffs, is that a lawsuit will follow up. And so they settled for Zoom for $85 million. So the other FTC example that I have is the largest settlement, if any of you recall, as we were in 2019, is that Facebook settled for $5 billion. We will see with the release of their confidential information if that's the end of it. I'm pretty sure probably not. But basically, that was the largest action in terms of the FTC. And basically, Facebook would have to enact new privacy protections, and the FTC forced them to create their privacy committee, the Facebook Privacy Committee, to basically monitor their privacy policies and practices. So that is kind of scary stuff for any business owner, is having this kind of oversight and then being forced, not necessarily overnight, but to periodically check into this while paying out damages, whether it be through a class action lawsuit or paying it to the FTC for fines and penalties. So I'm going to jump down to other federal laws. We're not going to go through in depth. I've kind of given you this kind of brief oversight so that you guys, again, can kind of analyze whether or not these may apply to your own data sets while you're considering your privacy policy in light of GDPR and CCPA. But I'm going to pull out a couple, but again, a lot of these laws do not target privacy in themselves. The reason why I put HIPAA first is because a lot of people think that the P in HIPAA stands for privacy. It doesn't. It actually stands for portability, because the law as intended was very concerned about personal identifiable health information being transmitted from healthcare providers, so doctors, hospitals, insurers, from one place to another. It was only through afterthought and kind of changing some things is that the HIPAA that we know today, when you visit the doctor, a new doctor, and having that, signing your consent form or in terms of what to do with your information, is kind of, again, as an afterthought. And on a note, in terms of timeliness, again, there is no HIPAA, there is no extra P for privacy. It's not there. It's more about portability and transmission of information. Another example is FERPA. For those of you with kids, it basically covers who can request student educational records and how colleges and schools and what they do with that educational information that they collect on students. The reason why I'm highlighting some of these is you'll see, especially with the CCPA, there are carve-outs and exemptions to the law. That is, if there is another law that covers the same subject matter or data set of information, you're exempted from complying with the regulation. So that's why I'm kind of hitting these. Fun one is, for those of you that remember VHS, I used to go to Blockbuster every Friday night. There is a VHS Privacy Protection Act. And the way it came about was a journalist who was doing investigative reporting on a Supreme Court nominee, Bork, basically requested his VHS rental history, like what was he renting, to see if there was any salacious or questionable kind of material that he was renting out from his local VHS store. Fun note is that in terms of today's modern society with the internet, obviously none of us use VHS, or I'm assuming none of you use VHS. The thing is it has been held it doesn't apply to Netflix yet. But the thing is a lot of times we look back at these laws and consider the changes in technology and societal norms and whether or not they should be updated. So that's kind of the mishmash of federal laws on privacy, or what I would call privacy adjacent at the federal level. So we're gonna jump into our first big law today, which is what the GDPR. GDPR is basically a data privacy law that went into effect in May 2025 in 2018. And basically it is the European Union's way of protecting its citizens, more specifically how their data is collected, used, and protected online. It tends to be very, from a US laws and from a US state's point of view, it tends to be very strict and very, what we call kind of preventative in the law, whereas American law tends to be more reactionary. And what I mean by that is we tend to slap offenders on the wrist or tell them don't do that again for their first offense if there's any harm or damage or injury, such as a breach because of your lax policies in privacy or data handling. That isn't really the case in the European Union style, where they tend to go after violators on the front end or do investigations. So what can you face is very heavy penalties of huge amount in euros of 4% of global annual revenue or up to 20 million euros, whichever is higher. So scary numbers, but let's go for you guys. Does the GDPR apply to you? You know, you may be a US web development company, I'm just using another state other than Hawaii, is if you're in Seattle, Washington, and you're mainly helping websites for Washington businesses, or in our case, if you're a Hawaii web developer designer and you're setting up somebody's website to collect information about Hawaii consumers, then probably not. But if you set it up in a way that you're going to be tracking and analyzing and collecting data from EU visitors to your company's website, then there are some provisions of the GDPR that might apply to you. So let's run through the analysis. First of all, is there an offering of goods and services? And again, this is to consumers. And again, while the internet connects us throughout the world, and using my earlier example, right, if there's a teen in Germany that can order pizza with pineapples here and have it delivered to a friend's house in Hawaii, and that's just a one-off, that doesn't mean GDPR applies. It has to be kind of an offering of goods and services that targets EU citizens. So regulators on their end tends to look for, are you advertising? Are you setting up ads in the targeted countries of the EU? Are you catering to EU customers? Again, one-off and occasional goods and services that they can interact because of the way the web works and internet and data communication technologies works. They're not really concerned about these one-off types of situations. It has to be kind of directed towards them. And then that's only one component of GDPR, of considering whether it applies to you. Next situation is, are you monitoring the EU citizens' behavior? This is where it kind of gets dicey in terms of how strictly this provision is interpreted or enforced by the EU. So the question is again, going back to it, if they're on an occasional EU citizen visit and you're collecting data still on them, is that sufficient for a regulator? What it seems to be is they really are focused and targeting, and you'll see by my examples later on about who they went after, of that's probably not in terms of their target for the regulation. Again, this goes back to my earlier discussion about, you know, what is the purpose and who are you selling your services and products to mainly. So that's why I was using the example of, escaping my, I was using the example of the German teen as a one-off. Yeah, you allow accessibility, but that doesn't mean you're targeting them in Germany to sell them Hawaiian style pizza, which I understand is not. I just use that just to kind of, where you come down on the Hawaiian pizza debate, that's another story for another day, but I am definitely in the camp of pineapple does not belong on pizza. So in addition, for the application, so those are your two main concerns, is going back to it, is there an offering of goods and services? And are you monitoring EU citizens' behavior, such as through cookies or, you know, collecting data and following up and kind of tracking them? But even if you get to that point, there are exceptions. So again, if it's a purely personal or household activity, and I use the example where you're collecting coworkers' email addresses to organize a potluck, again, it's probably rare that you're probably outreaching to somebody in Germany to schedule a potluck, maybe after the pandemic is done. GDPR doesn't apply to personal situation. It only applies to professional or commercial activity. So, and a counterexample to that, though, if you are soliciting and gathering your coworkers' email addresses for a fundraising event for a side business project, then that would be a situation where GDPR might apply to you. But this other exception, I think, is going to apply to most of you who are small and medium-sized business owners here in Hawaii. Organizations with fewer than 250 employees are GDPR exempt. Basically, you're free from record-keeping requirements, information, and basically applicability of GDPR. They're not concerned about smaller organizations, except, okay, this is where people are like, okay, this is why lawyers or people are kind of a headache. So running through the application analysis and then seeing if you fit under the exceptions, you do have to check an exception to the exception. If the main purpose of your business is data processing, basically, and there are certain categories and data sets and subjects. So therefore, if you are a tech firm and your sole existence is to be a service provider or vendor selling data processing services, even if you're a small organization, then the EU, especially if your client company, or if you're working with such a data processor, or you're targeting EU companies to help them with their data processing of EU citizens, then yes, the GDPR definitely has a chance of applying to you. So what is the GDPR? Well, basically it's a set of privacy rights on the user end and protecting users. And that is definitely EU citizens. These sets of 8 user rights are what the GDPR is looking to encompass and protect of EU citizens when they interact with private companies. That is when they hand over information, or you're using a cookie to track their behavior and basically, you know, how much are they staring at this piece of content? What are they clicking through? These are what the GDPR is giving EU citizens the right to do against your company in terms of their interactions with you. And basically, it is the right to be informed, the right of access, the right of recidification, the right to erasure, and I'm going to hang on that one and come back to that in 1 minute, is right to restrict processing, right to data portability, huge issue for obviously many US companies, right to object, and right in relation to automate decision-making and profiling. So for the two that I kind of highlighted, right to erasure, that is when an EU citizen, and if you are forced to be compliant with GDPR, asks you to delete their data from your servers and databases, and they're withdrawing consent of, we no longer consent to your data practices or how you handle my data. You have to immediately erase upon their request. But again, we're also in the habit of backup data and redundancy. You have to delete the backups as well because you're still holding it out. And this is really, Europeans have a notion of the right to be forgotten. And this is really ensconced in this right to erasure. The other one that I highlighted is right to data portability. In America, right, in terms of hyper competition or competitive, what this really means is they can ask you to remove their information and then take that and give it to another service. We are generally not in the habit of competing against ourselves in the US. So that is another issue. And not to mention, even from a programming and coding perspective, people use different systems. If you've encoded the data in one or data set in one way, and somehow you have to package that and send that to another like similar service, is it even compatible? So those are some of the rights, or not, these are all the rights that EU citizens have under GDPR to request a company follow. So why is it that way? Just to give you kind of an understanding and the market you will be dealing with should you want to expand and go after overseas markets in the European Union, is for Europe, generally privacy has been kind of a fundamental right since post-World War II. And again, you need to understand this kind of mindset because I think for a lot of US companies, they don't have this mindset of, yeah, sure, we understand it's your information you're giving to us, but it resides on our database. It resides on our process. We have to process and make use of your data information to make our goods and services and sending them back to you. That isn't really the case from the GDPR or the European Union kind of mindset, is that they're entitled that information you've collected from them is there, even though it resides on your database or you're trying to sell them products and services based on that they asked for. So again, that is kind of the way to understand, is that they're the ultimately in the driver's seat for their data. So where does that leave you? Okay, it's on all caps. It is kind of meant to go, you're not prepared, and it's kind of, as I've kind of said, is we simply don't kind of think about data information or think about privacy that way, right? So going back to my earlier situation, only really 3 states, Virginia, Colorado, and California, have begun to consider it. And you're going to see when I jump down to CCPA that the California law compared to GDPR is much looser and is kind of a halfway step. So again, we don't really think about data and information and privacy that way. And if you're going to do that, what I would kind of recommend is that if you feel that you're going to start selling and directing and targeting services to EU citizens and then collecting, processing, and monitoring their behavior with that data, that you consider using or relying on experts or consultants to kind of understand that fundamental shift in how data, because you're probably going to want to build your data systems and your processes in a way that approaches it from their mindset, because you don't really want to do the scramble situation or manual kind of looking for an EU, somebody in Spain who feels that you violated their data rights, and then, you know, sifting through the data just to find their particular information. You're really looking at for something that's adaptable and scalable. So things to consider GDPR, you're going to want to start at the very top, and that's why I said a shift in mindset is, you know, look at your data processes and review and kind of do your own audit. Then you're going to have to kind of take a look at your privacy policy, cookie policy and cookie consent statement. I'll get into that more, and I've actually kind of given you a template, and a data processing agreement. Yes, the GDPR actually kind of mandates and requires companies to enter or provide contractual agreements for data processing. You may not have one, or you might have a series of email agreements with a data processor, so can you handle it? But the GDPR requires something much more formal. We're not covering it because this is definitely for much, much larger organizations, but this is something that a compliance officer or somebody internally that is responsible for data management you may want to consider looking into what a data protection officer or compliance officer could offer in terms of processing of sensitive data. That is, you have to offer up an individual for a large organization to be compliant with GDPR. In addition, you have to do a data protection impact assessment. It's kind of like the equivalent of an environmental impact statement that we do here often when we, the state basically, or even a large company for development has to do. Same thing with data, is that prior to implementing new technologies that may be high risk to EU citizens' data and information, you have to do an impact assessment prior to rolling it out. So not going to cover those, and we're going to wind our way down through the GDPR. So I'm not going to run through this. You have the slide, but this, I basically took this from the gdpr.eu website. Fantastic site that is put on by basically a public-private partnership. Is that a private company runs it, but they are funded. You know, much like how Innovate and HDDC is helping sponsor and presenting this, they have the same situation in terms of a GDPR checklist for US companies. They do, and they understand US companies. And this is the checklist. I've kind of just narrowed it down, but I've given you the website. In addition, what is helpful is there's a number of forms and templates on that site that are kind of tailor-made for GDPR. So you're going to want to take a look at those. Jumping down for fines on companies, just kind of a scary kind of the scare part. But again, most of these are very large. So I have British Airways, Google, Marriott, and Amazon. And this goes to what I was telling you all about. They're more preventative in a sense that in terms of Amazon, they took a look at, and regulators investigated that, you know, Amazon didn't base its advertising practices on free consent that EU citizens consented to. And they basically used consumer data for targeted ads. I know many of you are like, we do that all the time here in the US, right? But under the GDPR, that's a bad thing. And they really expect you to comply basically to the letter of it, even if some of it is very difficult or very confusing. So another area is that Google, there wasn't a data breach. I know many of you are thinking, oh, well, aren't these only security breaches? Not in the case of Google. They ran afoul with GDPR because the regulator felt that Google's privacy policy that they put on their website was not easily accessible. That is, they used very confusing or obscure language, or they kind of played what I like to call hide the real policy by linkages and using overlapping websites and things like that. And so if it's not readily accessible or easy to understand, yeah, you can also get fined under GDPR. So take a look at those. Really, if you want to see what they got slapped with, it isn't only for breaches in data or having not best practices in terms of handling consumer data of EU citizens. Okay, jumping down to CCPA. What is it? It's the California Consumer Privacy Act. It was passed in 2017, and it went into effect in Jan 1 of 2020. Hooray! You know, right before the pandemic. Reliving 2020. Anyway, so companies that host data from any California citizen should comply, or that's just a general thought in the kind of overlay. And the broad goals of the CCPA is to give California consumers the right to know what info is being collected from them. They have the right to say no to selling or sharing of that info. And there are, again, legal consequences for violating those rights. So once again, we have to go through the analysis for you guys. Does CCPA apply to you? Well, in GDPR, there is no distinguishing for nonprofit, government agencies, or for-profit. But right here, right off the bat, if some of you work for a nonprofit and are wondering, and you do have services, or you're kind of out there, CCPA only applies for for-profit situations, and that you collect personal information and you're doing business in California and targeting their citizens. Again, it's that targeting situations. And you have to meet these thresholds. Is you have gross annual revenue of over $25 million, or you buy, receive, or sell the personal information of 50,000 or more California residents, households, or devices, or derive 50% or more of your annual revenue from selling California residents' personal information. So again, this law, CCPA, has actually a much more narrower target. Just because you happen to be in California, you happen to have California consumers or residents as your customers, that doesn't necessarily mean CCPA applies to you. You have to have the first component, which is the laws applies for profit business and you're collecting personal information. And one of these three things must be true. If that's not the case for you, then CCPA doesn't apply. So what is personal information? It's information that identifies, relates, describes, and is capable of us being associated with somebody individually, that is with a particular California resident or household. So this is what I was hinting at earlier. Not every piece of information you collect is personal information. And again, this only applies to consumers. It's a natural person. Again, so if you're dealing business to business, that isn't a consumer. However, where it is more broad is it does cover California residents traveling in and out of the state. And if their main residency is California, they are protected by this law. So I'm not going to go through all of this, but this is an example of personal information that is protected under CCPA. So if you are collecting any of these, this is what you have to be concerned about and whether or not CCPA applies to you in that prior analysis of applicability. So if this is what you are asking people to fill out when they set up an account, or you are getting this information by them filling out a questionnaire, then this is what CCPA is aiming to protect. Again, I had mentioned this earlier. If some of this information is already covered by another law, example is HIPAA, then it's exempt because the thought or policy under the law is that the other law, such as HIPAA, will cover the protections part. So you would have to check back with that law about what your compliance is. Again, it's going to be a case by case and a lot of by industry specific, which is why I started off with that laundry list of federal laws. So what are the rights that consumers get? What do you guys have to be concerned about respecting for a California consumer, right? We ran through the 8 of the GDPR, but this is what the consumer, basically Bill of Rights for the CCP is. It's the right to know about the personal information a business collects and how you use it. Again, there is the right to delete personal information collected from them. There are some exceptions. The right to opt out of their personal information being collected, and the right to non-discrimination for exercising their CCPA rights. That last one, if they exercise any of the prior 3, and you're going to selectively target all those California consumers exercising their rights, you're going to be in a lot of trouble under this law, because you can't distinguish or differentiate for people in California that decide to say, hey, I want to opt out of your service, or I want my personal information deleted from your servers. You cannot basically selectively discriminate against their use of their rights under this law. Basically, to ensure that consumers have the ability to exercise these rights, yes, you, the business, have to allow them to be able to access it or have availabilities of methods for contacting you and making such data requests. And at minimum, you need a toll-free number, and then you have to have a website address for them. You also must ensure that you have protocols in place to respond to these requests. So when they send it, or if they call you up or send it through your website, that you can do it through, that you can basically comply with the requests within 45 days, right? So this is why I had said earlier, you know, when you're considering GDPR or CCPA compliance, you really need to build your data infrastructure and systems of verifying that this is somebody who is allowed to then make this request, verifying that you've processed the request, and you have a limited time frame to do so. So yeah, you don't really want your employees to have to do a very manual or labor intensive effort to find this person's information and then comply, because that's going to take time and energy and resources. So very similar to what I talked about GDPR about compliance steps is, again, you're going to probably want to, and I skipped the step, but I was like, you're going to probably want to take and do an assessment of what you already have. You're going to want to update your privacy notices and policies, which is part of the latter part of this presentation. And you're going to want to update your data inventories, and you're going to want to implement processes to protect CCPA. So the next two slides cover points 2 and 3. And then you're going to want to make security updates, because you're going to need reasonable security. So what does it cost you to address gaps in your security measures? You may have an audit conducted, or you might do your own needs measure assessment and say, oh, we have vulnerabilities in security here, here, and here. But the question is, if it's going to cost you, a huge amount of sum of money and resources, is that reasonable to implement, or are you going to acknowledge that there are gaps in measures and then take reasonable security measures to plug those gaps? You're going to want to update your third-party processor agreements, and I'll get into that later, and actually a part of your packet of templates. And then, as I've already hinted, once you run through all that, especially for it's your customer service reps or people in terms of fielding these data requests, you want to make sure that they can handle the requests and information and navigate your own systems to make sure that usually it's going to be an opt-out or delete by a California customer under the CCPA. So about data inventories, I'm going to leave this slide. Basically, you need to identify the data and the categories and whether or not it's one of those many categories of personal information. This slide, I'd probably say, is for those of you who are software engineers, data management, and anybody building up the data inventory systems to kind of consider and work with who's in charge with them. You want to ensure your process, again, allows you to update the database, as you should be able to track all consumer requests. Again, it's that whole situation of, it's one thing if you get a one-off or a two-off or a few from California. It's another thing is if you implement this, that in one day you get 1,000 requests, right? How are you going to process all that? Okay, so this is one of the slides, of the many, that violates my wall of text situations. But this is almost akin to what I talked about for the GDPR of what is your approach to protecting the consumer's rights and how are you treating it. This is more of a step-by-step kind of what I call a kind of intellectual kind of decision making, but also the pragmatic situation is, you know, you have to be able to provide that toll-free number and website address. And then mainly specifically for item 3, determine your process for documenting these receipts. Is this really a California residence? How quickly can we turn around a response time to say, hey, we got your request, we are working on it right now. And then especially in those situations where you may be selling, and selling does not mean only solely exchange for money, can you effectuate the stop a sale? Because that's usually kind of what they're going to demand is, hey, stop transferring my information to this other third-party vendor that I have no idea who that is. Or, you know, how do you follow up in saying, hey, we looked into your data requests and we're going to deny it because it's improper or is untimely. Jumping down to the last item, the other issue with Ccpa compliance, very similar to GDPR, you need to have updates and basically to your policies and your information practices, so that basically your outsides, your policies presented to consumers match your insides. So you're going to be doing this on a 12-month rotating kind of basis to be in compliance and usually what that means is hiring an outside auditor. Again, more about that later, but yeah. The implementation to protect California is not a one and done. It is an ongoing process and a repetitive process. So that's why I said a lot of these laws require a shift in mindset and your approach to how you handle data. Penalties. So right now the CCPA is enforced by the California Attorney General. It can provide a private right of action in only certain situations, but hey, if you didn't mean it and it was unintentional, it's $2,500 per violation. If they can prove that is the California Attorney General can prove your violation of CCPA is intentional, then it's $7,500 per violations. The limited situation where a consumer can kind of bring a lawsuit against you is if you use a non-encrypted or non-redacted kind of situation for their consumer information and it is compromised due to a failure on your part. This goes back to why I kind of highlighted reasonable security. Then they can go after your business for statutory damages, which is between the range of $100 and $750 per violation, or actual damages, whichever is greater. The reason why I keep highlighting per violation, it doesn't mean, oh, hey, well, we violated 5,000 California consumers' consumer rights. It's just for that one breach. It's just for that use of non-encrypted information. No, it's per violation, which means each and every consumer of the 5,000, it is multiplied. So you're going to multiply that out. So that, of course, can quickly become very expensive. So yes, not only to add to your kind of hesitancy and scariness of CCPA, if it does apply to you, California has decided to amend it, and they have basically enacted the California Privacy Rights Act, which basically updates the information and the regulation in itself. So basically, you can kind of think of it as an addendum. It strengthens the rights of California residents, and it tightens businesses' regulations on personal information, and basically creates a new, rather than just the Attorney General, they're basically creating an enforcement agency called the California Privacy Protection Agency. That being said, here's the one silver lining. The thresholds that I use for applicability, if we go back up here, these three, the 25 million, 50,000 or more, or derive 50%, they have basically, California has increased those thresholds for CPRA, meaning that more small businesses are likely to be exempt. The only kind of questionable situation is that there is a look back period that even though this law kicks in effect in 2023, data collected between Jan 1, 2022 through 2023 still falls under the protection of CPRA. So again, you're going to want to be analyzing, do you fall under CCPA, and therefore do you need to getting compliant with CPRA as we enter into the 2022 year. So just a brief slide on differences between GDPR and CCPA. The short of it, as I'm hoping you kind of was able to piece out through that in this very highbrow kind of very rapid kind of look through the two laws, is CCPA is actually much narrower, right? It's the whole for-profit situation, and it actually tends to be less strict. Whereas GDPR applies to all businesses, and it can include even government agencies. So the issue that might be a good for you is that if some of you are GDPR compliant, you've already met the higher, more stricter bar. That is, you would likely need to have very minimal changes to be CCPA compliant. Now, if you're only CCPA compliant and heading to, again, selling services into or goods in the European Union, and GDPR applies to you under those applicability rules, then you're going to need to up your privacy requirements and policies and procedures, because that generally is the higher bar to meet rather than the other situation. So of the two, if you need to be compliant, sometimes you step back. If you're expanding your business and growing your business and you're really thinking of, obviously doing international trade or overseas business, then striving towards GDPR, even if it's not applicable, and there was that whole slide I talked about the way people kind of think about privacy and regulation, that is something you probably want to strive for as the market and people's websites change and update to be compliant with GDPR. So again, it is the more stricter of the two, but if things head towards that way, you're already going to be compliant if you have that kind of mindset. So shifting to our own state, it's going to be very minimal. In fact, I'm going to just breeze right these so we can get to the drafting part, which is what I think many of you are here for. So Hawaii does have privacy. It's in our state constitution, and there are statutory rights, and we have other protections such as identity theft, health data, financial information, and employment data. It doesn't need to be digital, obviously. Some of this is paper. In fact, sometimes the state is very paper intensive. I probably don't need to tell all of you that. That being said, for what we just covered from GDPR, CCPA, we do not have an online privacy or data pertaining to minors kind of specific laws. We don't have unsolicited commercial messages and Spam Act laws, and we don't have a requirement to post privacy policies on our websites. There are no such specific laws. There are two laws on data that do exist, and one of them is the data disposal law. And the data disposal law is all about taking reasonable measures to protect against unauthorized access or use of people's data information when you dispose of it, when you get rid of it. So that can actually include paper shredding, but that can also be digital information or data that you dispose of. And so yes, Hawaii does have a law about how you dispose of data. And again, this has been on the books for a while. There hasn't really been much made of it, but you have to take reasonable measures. Again, you have obligations and penalties, and it does include businesses and government agencies. and in terms of if you contract, so data destruction services, that you're responsible for them. Again, it's a per penalty violation, and it's $2,500. And injured parties, that is the people hurt by your unreasonable measures in data disposal, can sue. The other one is the security breach reporting law, and basically you have to report a security breach without unreasonable delay. And that is, you have to take timely notice to give notice to those people who have been affected by the breach. Now, the notice can be delayed if the police or government agency is doing a request. That is, they're asking you, please don't send this notice that a breach has occurred because we're investigating, because maybe it's hacker related or there's criminal activity. And thus, that is the only time where you don't need to be reasonable in the amount of time that you report a breach. Personal information, it's actually similar to what is covered under the CCPA for a data breach notification here in Hawaii, but it's actually a much smaller subset than that. So social security number, definitely, driver's license or your Hawaii identification card number. If it's a bank account number, credit card number, access code, passwords, things like that are what we're kind of looking for. It doesn't include personal information that is publicly information that is lawfully made to the general public through your government records. There's a lot of government records that it's public record, so that doesn't apply. So I want to move along because I want to have enough time to get to the drafting. Like I said, this is a very meaty and weighty subject. You probably could spend a week on all the data privacy and data cybersecurity measure of kind of laws and things that you need to do. I just wanted to highlight here is that, again, California, Colorado, and Virginia are the only ones that have something that amounts to privacy protection. That being said, the Hawaii State Legislature has brought up this issue multiple times in the legislature through bills. I believe they converted a bill or had a resolution for a task force to investigate. So, meaning that if you've already thought about your privacy game or complying with GDPR or CCPA, you're probably ahead of the curve for Hawaii, because sooner or later, the Hawaii legislature is probably going to enact Hawaii's own privacy law regulating the way private companies handle data that's collected. So it's wise to probably, and thank you again for all joining me, even if CCPA and GDPR don't directly apply to you right now. But this might provide you a roadmap in terms of implementing new policies and process towards data. The other thing I would like to let you know is you really shouldn't just be concerned with GDPR, even though we focus on it today. It isn't the only area of the globe that has its own privacy regulation. I chose a lot of Pacific Rim countries, or basically where our Hawaiian Airlines or other air carriers that fly here fly back to. So Australia, Canada, Japan. I don't think there's any direct flights to Mexico. You have to stop off somewhere in the Southwest or California, but still, and South Korea. They all have personal information or privacy acts. And again, if you're doing business there, you're going to want to run through the same analysis, do our privacy policies, do our websites and apps, and do our terms and conditions with their citizens comply with their laws. Okay, so this just rehashing overall keys to compliance. So let's think about your policies. Actually, when you get into drafting or contacting an attorney or having a compliance officer working on these. Contracts versus policies. The reason why I bring this up is there's always confusion about the website's terms and conditions or the app's terms and conditions versus what your privacy policy is. Contracts are enforceable agreements. That is, you sue for a breach of contract contract. So a lot of times you'll see consumers sue companies under these laws or similar laws, or maybe not even under the privacy law, but just bring a breach of contract claim for violating your own contract. So understand that. Whereas business policies are more of a course of action. They're not a promise. They're more of, this is how we do things. And so what this boils down is enforceability is that policies typically are not enforceable or binding unless a government regulation says you have to do these things. But it can be made as a material term of contract. And the way this comes about is frequently when you're updating your website terms and conditions or your app terms and conditions, you're also updating your privacy policy, and you have cross linkages. You refer to one or the other as see privacy policy, click this link, or this is a part of your terms and conditions. So by doing that, sometimes you're making your policy a part of the contract. So contracts versus policies, we already went the FTC, discussed that. Again, for GDPR and CCPA, there are a number of contractual agreements that you have to have. They are mandating that you have these contracts. So again, this is kind of where compliance really forces the change in operations, because you're going to be in a binding enforceable agreement. Okay, so when drafting, so DPP, when you're drafting a data privacy policy, actually, this is where legalese and using catchphrases or new terminology can actually cause you problems, right? I talked about the Google situation for GDPR for making their language unintelligible or not readily understood by somebody reading it. So KISS applies there. It is keep it simple, stupid. In fact, for me, when I'm reading somebody's privacy policy, I am a fan of the very short that poses a question as if you're the consumer, answering that with the short answer is, yes, we do track your behavior. We use these kind of cookies on our website, and this is the information we're tracking and gathering from you. And then the specificity follows of going into it, because it keeps it simple and it makes it readily understandable to the average person who does decide to read your data privacy policy. You really want to start off with your company's stance and approach, which is why I'm urging a shift in thought and mindset for compliance, because you want to be kind of proactive rather than starting with the equation of can I bill it and just sell and then figure it out after. I'm saying you should consider privacy from the starting point as a part of the process and what your company's statement on that is. Then going through those analysis of GDPR and CCPA, where I ran you through, does the law apply to you? What kind of data are you collecting, and is it protected is the next kind of question when you're drafting your DPP. And then again, one of the key critical things of why companies get slapped with these fines is, what are you using the data for? What is its purpose? The next kind of level down is that if a consumer has the right and they don't like the way you're using or what the purpose of the data is for, how do you process those access requests? Sorry, that was my Siri. Storage. How, where, and how long is the data collected and stored for, right? We're going into that deletion situation or opting out of referring back to consumer data requests. And again, for the company, because data doesn't exist in a vacuum, even though we sometimes analyze it that way, is there company-wide coverage? What about employees? Who has access to the database? Who has access to passwords? And are people being trained to also have this shift in mindset of protecting consumer data? So that's the considerations of, and I know it seems kind of ridiculous to try and keep it simple on the one hand, but then addressing all the operational and informational kind of structural changes that you have to do, and then training your employees. But that is basically where you're heading towards if you want to be compliant with data privacy. So, not to add to your plate, right, related documents through your data privacy. Sometimes what I see, which is problematic by clients or other people, is they take a piecemeal approach. They think we're just going to do the data privacy, or we're just going to look at the consent, the cookie consent. They forget, and that's why I started off with the slide of contract versus policy, is what does your website and app terms and conditions say? And then cookie policy and cookie consent statement, it actually, for GDPR purposes, those need to be separate things away from the privacy policy. What are your third-party agreements? What does your employee handbook say, or your internal documents? Do you have insurance that covers data privacy or cybersecurity situations? And generally, any document in your organization that dictates or how people handle consumer data will probably all need to be updated or at least reviewed. Cookie policy. We're running out of time, so sorry, but thank you for joining me. But I'm going to try and wrap this up and hit the other document I gave you in terms of the template. So cookies policy and cookie consent notice. For GDPR purposes, you cannot embed the cookie policy in your privacy policy. They have to be two separate things. Try visit a number of European companies' websites, or what you've begun now seeing is that little pop-up or close over window. And actually in your example packet of this, I put Bank of Hawaii's a website. There's a little pop-up that says, hey, we use cookies this way, do you accept? That's what the cookie consent notice or the statement is. And the user visiting your website has to click, I accept, right, for the cookies to be enabled. And frequently it links back to your cookie policy. So you're going to want to take a look at that in terms of setting that up as a separate site and a separate policy, as opposed to embedding it in your privacy policies, which is what many US companies do. Oops, I'm sorry about that. The other document that we're concerned about, and jumping down through it through relying of third parties, many of you rely on other third parties, especially if it's not your core competency or your sole focus on data processing, is outsourcing a lot of activities, such as collecting, and then storing that data, analytics, and it's hosted through a whole bunch of plugins, apps, or basically hiring a vendor to do your data processing for you. When you rely on third parties, they may be in your mindset a contractor, but for GDPR and to some extent CCPA process regulation, you are responsible for them. GDPR considers you what's known as a data controller, and them, this third party, this contractor, as a data processor. So they force you to have a data processing agreement. Again, you want to take a look at that link I gave you to gdpr.edu, and there's information for that in terms of what you can kind of implement in your contractual arrangements between you, the data controller, and a data processor. For CCPA compliance, it talks about a third-party processor agreement. And what I've provided in your packet that you're going to get from Ellen them at HTDC is a third-party processor addendum. That is, you are amending the agreement that you have with your data processor to be compliant with CCPA. Again, it's just kind of a roadmap and a template, but these are the things you want to analyze when you're negotiating your contract with your data processors, is that you want them to be compliant with the law that you're subject to because of your approach or you're gathering California consumer data. Final two slides is cybersecurity audits. You're going to want to consider doing an audit, especially for GDPR and CCPA purposes, because as I said, you have to do it periodically anyway. But if you're considering of entering this, or you have a prototype system, or you want to troubleshoot your system, you're going to want to hire a cybersecurity firm that conducts an audit. The reason why you want somebody outside is it avoids conflict of interest. When you try and do your own internal audit, it is subject very much to employee interest or kind of, project territory by people in your organization. If you're going with an outside firm, they're going to analyze it as if they're coming from outside and looking in. And then you're going to have a roadmap how to update or plug those holes. And again, going to that reasonable measures, it'll give you something to consider about what is a reasonable measure for us to plug these gaps in our security in terms of protecting people's data. Finally, consider cyber insurance if you don't have it. On the privacy end, it typically covers liability claims against your company, including litigation, defense costs, indemnification, and regulatory investigations by federal and state and county levels, and also GDPR, CCPA, and kind of FTCA fines and penalties. So if you don't have cyber insurance, it's something to look into. Okay, I realize we've run out of time. I'm going to ask Ellen to hop up, and I'm happy for those of you who want to stay for a few minutes because I do want to take some questions. And again, I apologize for running over. Lots to go over, but again, please use my slides as a starting and a roadmap on this very, very broad topic. And if you really want to update your privacy matters, because I really think it's coming, even on a Hawaii level, even if it's watered down and not at the GDPR, you need to consider updating your privacy policies because people are going to begin to expect it as their right. Again,
Great.
So sorry for overrunning.
No worries, Ryan. Thank you so much. We just have one question in the Q&A. And I think it was from Marilyn. She's asking if there are examples for GDPR compliance. I sent her a link that showed a couple for large organizations, but I'm not sure if there's anything on your side, Ryan, that you wanted to share.
So going back to it, for huge organizations, especially, let's just use the, let me jump back up to it. Sorry, I'm looking for the slide that says, sorry, Marilyn, and sorry, everybody else. Oh, there it is. Yeah, especially if you have an organization that's going to be over that 250, you're definitely in the larger category. The issue I understand for large organizations, especially if you're consumer focused and oriented, and people interact with your company that way, the data doesn't exist in one department or one group or one functional unit, and it's going to get spread throughout. So you really need to get buy-in and stakeholders input, but also for your IT and tech and IT security people, they need to tell you what is currently capable and what is not, and whether or not you have to basically tear down the whole system and start from the bottom up to address when a data request comes in from an EU citizen is, hey, I want my information deleted. Whether or not your IT infrastructure can kind of meet that currently, and you can band-aid it, and if you really want to band-aid it that way, or if it's something that requires a whole new mindset and approach of when you're collecting that data, which can take months, if not years, probably definitely months. And so again, Marilyn, unfortunately, there's no easy answer for large organizations. The hope is that senior management or top leader executive can provide the resources for you to do a true rollout and implementation. Because as I showed you, the cost concerns for the GDPR are huge if it does apply to you. Now, attorneys might argue in terms of, enforcement. Well, the EU commissions and regulators are over there, but we're over here all the way in Hawaii. So even if they assess a fine, through treaty and agreement, there are other situations, right? Sometimes penalties in other countries do apply to you, and they will eventually get to you. So that's not exactly what you want to rely on for being non-compliant. I'm urging, if GDPR does apply to you, and I use the Google example and the Amazon example, is Google did not make their privacy policy readily accessible or understandable. Yes, they use a lot of fancy, sometimes legalese or technical ease, which was basically very confusing. And the GDPR regulators, the EU regulators, slapped them down. So for your organization, Marilyn, I'd say this is a conversation to have now if you haven't already had it and you're thinking that GDPR will be something that you have to comply with or already complies, because it only takes the investigators to catch wind and then begin digging and looking at their website. As I said, the EU's approach to their regulation is preventative. It isn't after the fact, whereas a lot of times our situation is the breach has happened or a violation of the contract has already happened, like in the FTC cases. So that's kind of my long answer. I'm so sorry, Marilyn, that yeah, you're gonna have to get in a lot of buy-in from, if you're especially in the middle of executive and getting resources, but you're also going to have to talk to your IT experts. Does your system comport to or can it comply, or do you have to build something completely new?
Yeah, thank you, Ryan. Another question, I think we can only take one last question from Babs. So he's asking, he or she, sorry, is asking, do all websites require privacy policy or cookie consent statement? And he's saying that he doesn't know if any cookies collected, there's any cookies collected on his new website.
That is to basically, if they're submitting, well, even then it doesn't need to be active, because some things passively, when you right, when you're building your website, you kind of just put in plugins, add-ins. Oh yeah, that sounds good. I was like, oh, and some people don't even know that they have all this data and information because they don't know where it's getting sent. For that type of situation, you're going to have to definitely ask whoever built your website, or if you're doing it yourself, you probably want to get outside help to kind of take a look at your website or app about what is being collected or how is your website being used. Very topical or broad stroke answer is, generally speaking, if you have what I call a glorified billboard website, that is, there is no interaction, that people just visit it. So I use this as like an attorney example of, if you're just going to visit it, or a doctor or dentist, and it just has, this is the name of my business, this is our telephone number, and this is how you contact us, but you don't even fill out a form or anything, chances are there are no website terms and conditions. There are no privacy or cookie policy, because there is no interaction. It is akin to exactly a digital billboard. It is a very passive thing, and you're just putting it out there. If there is going to be some level of interaction, that is, they have to input or process or send you information through your website, then there is a data or privacy concern, and you may want to put it up. But in terms of terms and conditions, it is a contractual arrangement. What people don't understand is, I don't need to give you money for what we call consideration in legal enforceability land, right? We now recognize, especially if you watch the Netflix documentary or any number of documentaries or articles, is that the way social media companies is, they provide service in exchange for your privacy information or your data. That is the exchange. It is this for that, and that is a contract. So again, to address your question, if you're not collecting data and information for people who visit your website in exchange for rendering services through your website and app, and again, it's more of a digital billboard, then chances are you probably don't really need terms and conditions and a privacy policy. But if there is any interaction, even minor, then you're going to want to analyze what that interaction is and then consider implementing both website and terms, conditions, and a privacy policy, or in some cases, maybe just one or the other.
Awesome. So I know, Babs, you had a longer question, but I think we've run out of time. We actually have to. But I can capture that question. I'm not sure, Ryan, if you'll be able to help him with it. But yeah, it's actually in a Q&A, but I think we might have to take it one-on-one after this session itself. So I will capture it, Babs, and I'll forward it to Ryan. If he can help you, he will respond. But I think just based on what I'm seeing, it probably the best thing you could do is to ask your IT person to help you with this customer information management on your side. Okay, let's see. Okay, so I think that's about it. Thank you so much, Ryan, and everyone else who reached out today, who joined us today for this webinar. As mentioned, we have another upcoming webinar on November 10 on EDI technology. So if that's something that's beneficial to your company, definitely RSVP and join us on that day itself. Ryan, is there anything you want to leave the audience with? Any last words? So Ryan, can you hear me?
Hey, Ellen, if you can hear me, I'm sorry, my headphones died on me.
Oh, I see. No, I was just saying, any last words for our audience before we let you go? Okay, I think Ryan's having a little bit.
Yeah, sorry, technical difficulties. There you are.
Yeah. Any last words for the audience before we let you go today?
Again, thank you for joining me. Sorry we went over. Again, I think we're seeing a shift in mindset, even though we're not maybe as far as long as the European Union in terms of protecting data and privacy rights, especially with the Facebook scandal accelerating congressional interest and many states following California's lead. You're going to begin to see more privacy rights, whether they're the same or not, especially in Hawaii's situation, if we enroll something. You want to begin the conversation now about how you're collecting consumer data and whether you're respecting their privacy. On the business cost end, because I understand it's costly to do this, you want to basically begin road mapping your systems and services to make it scalable, because if it's a very manual intensive effort for the data requests, you're going to be eating into your time. So it's something to consider now, even if, again, if these laws don't directly apply to you, begin thinking, at least thinking about it. But other than that, let me know if you have questions. I do initial consultations. If I can't work with you, or if you have other ideas, I'm happy to send referrals. But other than, begin outreaching to your panel of experts and advisors, attorneys, IT experts, cybersecurity. Begin kind of road mapping. And then the insurance, which is why I end on it. Talk to your insurance agent, see what kind of cybersecurity policies that you can pick up for your organization. Other than that, thanks for joining me.
Awesome. Thank you so much, Ryan. And thank you everybody for joining us today. We will share the recording on our website in a couple of days. Thank you.